America, there are 4 principal constitutional defects in the health care law recently signed by President Obama. The statute has many very odd parts to it that are all subject to challenge, like the federal takeover of student loans, the creation of a health care army, which includes members of the state's National Guard, and the hiring of 16,000 new I.R.S. agents. But the main constitutional violations address what the Congress has ordered the states to do and what it has ordered individuals to do. These unconstitutional and troubling provisions order the states to increase state taxes and spend the money collected on health care, order individuals to acquire health insurance that provides coverage acceptable to federal bureaucrats, transfers regulation of health care from the states to the federal government, and puts a federal bureaucrat between patients and physicians. Question: can the federal government tell the states how to spend state-generated tax dollars? In a word, no. Recall that the states formed the federal government and not the other way around. When they did so, they gave away only 17 specific powers, all written down in the Constitution, and they expressly retained for themselves what they didn't give away. At the time the states formed the federal government, they were independent nation states, and the powers that they gave to the new federal government were aspects of nationhood, such as raise an army and navy to defend the country, operate a court system, provide for standard weights and measures, coin money, and run a post office. These are all aspects of nationhood with which the states would no longer be concerned. But the states retained for themselves the power to legislate for the health, safety, welfare, and morality of people in the states. The federal government simply has no authority under the Constitution to regulate in those areas or to tell the states how they should do so. Now, the President has argued that the power the Constitution gives to Congress to regulate interstate commerce permits it to regulate health care. Question: when you go to your doctor, is it for a commercial purpose or is it to enhance your health? The power to regulate interstate commerce was given to Congress so it would keep commerce between the states regular by eliminating state tariffs. It was not given to regulate purely local professional services like visiting a doctor. Can the Congress regulate a Tupperware party? Of course not. Since the federal government cannot tell the states how to tax and regulate in the areas reserved by the Constitution to the states, since the regulation of health care has been done by the states for the past 200 years, it follows that the Congress cannot order persons to purchase health insurance. The Congress can't order us to eat or to wear shoes, even though those are both beneficial to us, so how can it order us to buy health insurance as well? The Supreme Court has held that the most private of our conversations, and thus the one most insulated from government intrusion, are those between a patient and a physician. Yet the statute just signed by the President violates that right to privacy by requiring physicians to share private medical information with federal bureaucrats, and by permitting those bureaucrats to direct the physicians how to treat the patients. The government cannot run the post office. It can't run Amtrak. It has bankrupted Medicare, Medicaid, and Social Security. Can we really expect it to manage health care? The Congress that enacted this monstrosity recognizes no limits on its own powers. It does not take seriously its oath to uphold the Constitution, and it acts like it is a general legislature that can right any wrong, regulate any activity, and tax any event. That is 180 degrees from the values of inalienable rights and limited government that the framers gave us. The President signed this historic legislation into law earlier this week, but a new battle is beginning as states challenge the law's legal grounds. State leaders from across the nation have argued that this law infringes on their states' rights, and they're using the Constitution as their main instrument. Joining me now is Florida's Attorney General Bill McCollum, Randy Barnett, constitutional law professor at Georgetown Law School and author of Restoring the Lost Constitution, a terrific read, and John Tamny, editor of Real Clear Markets. Gentlemen, welcome to the Glenn Beck program. General McCollum, to you first. Tell us about the lawsuit that you filed. What does it argue, and who is it against?
Well, Judge, first of all, I agree with you completely and all of the 12 other attorney generals who joined us in this lawsuit that the Founding Fathers never intended to give the general lawmaking powers to the federal government. They reserved only the enumerated powers to the federal government. So our lawsuit challenges the constitutionality of the entire law, but it's premised on 2 or 3 basic problems with this bill. Number one, it's the individual mandate issue. It's the question of the constitutionality of requiring somebody for basically just living, for no economic activity, for not engaging in any activity for that matter, to buy a health insurance policy or be fined or be taxed. There is no enumerated power that allows that. The Commerce Clause is not inelastic. Court decisions have said that, and we are arguing and will argue that, I think, very effectively in the district court in the Northern District of Florida, where this has been filed, and then on to the Supreme Court. The second basis for this lawsuit is the commandeering of the assets of the state. In my case, in the state of Florida alone, for example, we're going to have to pay billions of dollars more in our state to comply with this law, partly due to the fact that you're increasing the rolls of Medicaid recipients. More of them will go there, not only because there are going to be eligible, more people will be, but because of the individual mandate that will encourage more to sign up. And that's going to mean we'll add 1.2 million new Medicaid recipients to the already existing 2.7 million in Florida at this huge cost. And then there are, of course, the provisions that require the states, without getting any refund from the federal government, to set up insurance exchanges, et cetera.
Right.
This is the largest commandeering of assets ever, and we feel as states that this is a violation of the 10th Amendment and the sovereignty of the states under that. But
Professor Barnett, General McCollum uses a term of art, commandeering. Those of us who study the Constitution know that the Supreme Court has ruled that the Congress can't commandeer, take over, remove the discretion from state legislatures. Attorney General McCollum argues, and I was in Florida last week speaking to one of the Florida state legislators, that they have to raise $1 billion new and spend that money the way the feds tell them. Question, can the Congress order a state legislature to raise state taxes? Question, can the Congress tell a state legislature how to spend the monies thus raised by those taxes?
Well, the bill has been cleverly worded to avoid direct commandeering. Essentially, what the bill says is that the states are going to lose their Medicaid funding if they don't do what Congress wants them to do. But the states, the defenders of the bill would say, have the option of doing what they want and then losing their Medicaid money. So that's the reason why it's not a direct commandeering of the kind we've seen struck down before. But when the Congress passed a law that required or that asked states or made a condition of federal highway spending that they raise the drinking age to 21, the Supreme Court upheld that rule because they said it was not coercive. And the reason why it was not coercive is only 5% of federal highway money was going to be withheld, and that's the reason why it wasn't going to be coercive.
And because the states could have rejected the federal highway money if they want. The Supreme Court said you can't have it both ways.
But they would only forfeit 5%. Here, the state of Florida is being asked to give up 100% of its Medicaid funding from the federal government if it doesn't do what the federal government wants to do. I think that the court is going to find, or is likely to find, that that's pretty coercive. And I commend Attorney General McCollum for bringing this lawsuit, and I think the lawsuit has great merit. But I don't think that the American people who do not like this bill should put their faith in the courts to save them. I believe that political action of the kind that everybody's talking about is going to be necessary, and you just cannot count on the courts to do this. I would say people who oppose this bill should not count on the courts to save them, and people who support this bill should not be 100% sure that the court is going to uphold it.
One of the most effective ways we have maintained freedom in America is through federalism, the separation of governmental functions between the states and the federal government. The states have the principal governing functions in our everyday lives, and the federal government governs in areas of nationhood and foreign affairs. The framers who set this up wanted to assure that the states could check the feds and the feds could check the states, so that the tension between them assured that neither side would gain too much power and destroy individual freedom. This also assured freedom of choice. As Ronald Reagan was fond of saying, in America, you can vote with your feet. If you don't like the laws in one state, you can move to another. This is no longer the case in America, where the government is too oppressive and all the states are the same. This we must change.